Hi, this is David Bliven, Bronx and Westchester divorce attorney with another episode of Lessons from the Divorce Wars. So, recent potential client comes into my office. He lost his job through no fault of his own. He wanted to come in, file a downward modification of child support application. Mistake number one, he lost a job a while ago. So he said, hey, is there any way I can get back some of the arrears that accrued in between times? Answer, no. So the law says you only get relief from the day you file your application, not from the day you lost your job. So if you lose your job, you have to go into court right away. That's number one. Number two, many people don't notice. You have to keep track of your diligent job search. That is a requirement in the law. Unless you're disabled, and that's another issue altogether. But if you lost your job through no fault of your own, you have to prove you have to prove that you lost your job through no fault of your own. Don't assume that. Don't go into court and say, oh, judge, I swear it, I lost my job. I got laid off. No. You either have to produce proof of unemployment benefit receipt or correspondence, a termination letter from your employer saying, oops, sorry, we have to lay you off. Otherwise, you may actually have to subpoena your ex-employer into court. So that's number one. Number two, the diligent job search. So what does that consist of? If somebody's completely out of work, I say you got to make looking for a new job a full-time job in and of itself. So the court has to actually see that. You can't go into court, think you're going to win your case and say, magistrate, I swear I've been looking for a job every place. I can't find one. Sorry, no one is here to take your word for it. You have to document it. So most of the clients that I represent that want to make that argument to the court, they literally come into court and slap a 3-ring binder down on the table and say, Judge, I've been looking for a job everywhere. I haven't been able to find it, and here's the proof of it. Well, that's part of your proof. Ultimately, if you go to trial, you enter that. It's Exhibit A, and the other side has the opportunity to either cross-examine you or potentially contact those employers that you supposedly submitted jobs at and verify that you actually submitted an application. The other thing theoretically that they could do is hire a vocational expert that may be able to come in and say, hey, you claim you've been looking for a job everywhere. You really haven't. And here's the jobs that are out there that you could have looked for and you really didn't make quote-unquote diligent efforts. So those are all your obligations. Don't think that it's just as easy as filing a petition, going into court and saying, Judge, I lost my job, I need to lower child support. It's not that easy. And unfortunately, fathers get that wrong, because it's almost always the fathers that are paying child support. So that's the reason I say that. The fathers get that wrong all the time. And I keep seeing decisions from magistrates that dismiss their applications, and then the fathers come to me after the fact and they're like, why did my case get dismissed? Well, because you didn't satisfy your legal obligation. That's why. So if you're looking for similar answers to questions like these, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.